All rise. The Court of Appeal and for the 5th District of the State of Florida is now in session. The Honorable Vincent G. Torpey, Chief Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to the 5th District Court of Appeal. We have 3 cases on the docket this morning. A criminal case, which lawyers will get 15 minutes per side, and then we have 2 civil cases where you'll get 20 minutes per side. Judge Sawaya is on the panel to my right, Judge Cohen to my left, and I'm Judge Torpey, as the marshal indicated. If anybody's got any of these devices that make noise, would you do me a favor and double check them right now to make sure that they're in the silent mode so that the attorneys are not interrupted during their arguments. We'll take the cases in the order they appear on the docket. We'll take a break after the second case and have coffee if the lawyers care to join us in the lawyers' lounge. And with that, the court will call Mr. Pono, you have to help me with your client's pronunciation.
It's Kim San-Yi.
Kim San-Yi versus State. And I got 5, how much rebuttal time you want?
4 minutes, Your Honor.
4 minutes, all right.
May it please the court, my name is William Pennell and I represent Kim San-Yi, the appellant in this case. As noted in the briefs, this court to reverse Mr. Yi's convictions for 6 reasons. Based on the limited time I have today, I'm going to focus my arguments on issues 1 and 3 of my initial brief. Certainly answer any questions the court has on the other issues as we move along. An important fact in the case is that Mr. Yi was charged with 5 separate counts. It's our position that he was given the correct instructions on count 1 and 2 and found not guilty on 1 of those counts and guilty of a lesser included offense of battery on 1 of those counts. On the other 3 counts, counts 3 through 5, which we believe the jury was given an improper instruction, he was found guilty as charged.
I don't think the state disputes that it's an improper instruction there. I guess their argument is that somehow that was not a real issue in the case. Why don't you speak to that?
Sure, Your Honor. It's our contention that the instruction is erroneous and it was a disputed issue at trial in this case, that the defense was that the alleged victim made up these allegations, but that any touching that did occur was incidental, playful, tickling, joking around, and that was addressed in the closing arguments of both the defense and the state. So it was a disputed issue about whether the touching was, in fact, lewd or lascivious. I think the basic definition of disputed is that there's an argument about it. Both parties, the state and the defense.
Well, it wasn't conceded by the defense.
It was certainly not conceded, and I think it was argued by both parties in closing. Repeatedly in closing argument, Mr. Yi argued, and he referred to the controlled telephone call that was part of the evidence, that there was when I touched you, I was joking, I was kidding, that's playing, quote, that's not a lewd act. A parent smacking you on the butt, that's not a lewd act. That's part of Mr. Yi's closing argument. He also points out that when the alleged victim was confronted, when she confronted him in the controlled telephone call, she brought up the idea that she was ticklish. So there was multiple instances in the case, in the evidence and during closing argument, where this idea that touching that occurred was playful, tickling, patting on the butt, which would obviously not have a lewd intent component to it. The state, in their closing argument, when discussing the alleged touching, said, quote, he was truly lewd and lascivious because that's no place to touch. So this was a disputed issue. It was raised by both parties in closing argument. What wasn't disputed and what would not be fundamental error if the instruction in this case left out the element requiring the state to prove the defendant's age. That would be the opposite. No one contested or argued that he was under 18. which would make it not the crime. So that's the distinction. We have an issue that was addressed in closing by both parties and argued throughout the case, and an issue that was never an issue, the defendant's age. Same thing with the alleged victim's age. No one argued that that when this touching occurred, or the alleged touching occurred, that she was over 18 or over 16. That would not be fundamental error if the instructions in this case on counts 3 through 5 left those elements out. We have a much different fact here where this is the main element of the case.
We don't know who prepared the jury instructions on this from this record, do we?
I think we do, Your Honor. I think throughout the case, throughout the record, and I went through this yesterday, the prosecutor repeatedly indicates that he was working on the jury instructions and would get them to the court. And so the state prepared them, provided them to the court. The state didn't catch the error, the judge didn't catch the error, and the defense attorney did not catch the error. But there's no evidence in the record that Mr. Yee's defense lawyer prepared those instructions and asked the court to give those instructions.
So he didn't object?
The sole record evidence on that is after the instructions were given, that the court asked, does anyone object to these instructions? And both parties, the state and the defense, said no objection.
I know you didn't indicate that you were going to spend any time on what is I think your last issue, the confession, but I'd like to hear what you have to say about that.
Sure, Your Honor. It's our contention that first, from the starting point, the trial judge in this case applied the wrong standard, and that renders the decision to deny the motion to suppress fundamental error. As the court knows, this court receded from its decision in Johnson, in the Wheeler case. In Johnson, the court had previously said that all evidence at a suppression hearing needs to be viewed in the light most favorable to the prosecution. Subsequently, in the Wheeler case, this court receded from that and said, no, it's a totality of the circumstances with no favoritism to either party. We know from the court's order that he applied, the trial judge in this case applied the Johnson standard, so was looking at the entire case through the wrong lens. He was looking at it as the case law stood at the time in the wrong way, giving a favoritism to the prosecution. So it's our contention that based solely on that, Mr. Yee should get a new trial and a new suppression hearing where the appropriate standard is applied. As to the elements, I think even a fair...
Is that the relief you're seeking on that issue, is a rehearing using the proper standard?
I think we should get a new trial and a new hearing.
Well, I understand that, if you get a new trial, right. But you're not asking us to rule that the confession should be excluded as a matter of law.
Your Honor, I think I would ask for a new hearing and a fair consideration under the appropriate standard. I do think the facts as established at the hearing established he was in custody and was entitled to Miranda warnings, but I think it would make sense that the trial judge be able to make the first ruling on that under the appropriate standard, and then if we disagree with that later, we could always bring that up on appeal again.
All right.
But I do think a consideration of the factors as laid out in the brief do establish that he was in custody. I think he was aggressively approached by the officers at his place of business. He was never told that he had a choice in speaking with these individuals. He was confronted with evidence of guilt. He was not permitted to speak with the interpreter who he knew. I think he was controlled to the extent that he would believe he was in custody and was not free to leave.
What's your best precedent on that?
Your Honor, I would cite the Ross case and the Lee decision from the first DCA, the Lee and the CF case from the first DCA and the fourth DCA as my best precedent on that. I do think a consideration of all the issues suggests he was in custody. As to the first issue, again, I think there's no legitimate argument that this was not a disputed issue at trial. I think this was the disputed issue about whether touching occurred. It's different than a situation where, again, where the age isn't in dispute or the state relies on the Battle decision, and they talk about a situation where the sole defense is mistaken identity. And in that case, an error in a robbery instruction would not be a problem because the sole issue for the jury to determine was whether the defendant was at the scene and whether he was the individual. That's not the case here. It's clear from the record that Mr. Yee had contact and touching with the alleged victim. The question is whether it was lewd in nature, and the jury was never asked to make that determination. And that's the critical determination in this case, and for that reason, it's our contention it's fundamental error in this case, and that counts 3, 4, and 5 should be reversed for a new trial. Issue number 3 was it's our contention that the prosecutor improperly elicited testimony from Detective Watko as to the credibility of the alleged victim. As the court knows, the credibility of the alleged victim was the main issue for the jury. Her credibility was substantially impeached, but there was no eyewitness testimony, no physical evidence.
Whether that was preserved.
Your Honor, I think there was 2 improper statements. I think the first statement was certainly preserved. There was an objection to the question. That objection was overruled.
What was the objection?
Improper bolstering, Your Honor. And that's at page 381. The objection was, quote, Your Honor, I'm going to object to any of her credibility. The judge asked, what's your grounds? He says, I think he's trying to bolster this officer's opinion of her credibility. That objection is overruled, and then the officer is permitted to say there are times, just based on the way someone's answering questions, their answers will become inconsistent sometimes, and I received none of those indicators with Ms. Che. So that particular one was certainly preserved for the record, and the state argues that the door was opened by Mr. Yee. I disagree. He established inconsistencies by just asking the officer fact questions. What was her answer to this question? What was her answer to this question? He never asked the officer, what's your opinion of her credibility? Only the state did that. So the state transforms this officer into essentially a human lie detector, and that's the jury's decision, not the officer. And it's our position that the state overstepped their bounds, the judge allowed it and made a mistake, and that this case is right on point with this court's decision in Johnson from 1996, where the state was permitted to elicit testimony from a defense witness about an alleged victim's credibility.
Mr. Pennell, on the argument as to the right to remain silent, initially the objection was shifting of the burden. And then at some point afterwards, but it's difficult to, I'm trying to get the timing of that, approaches the bench and makes the Fifth Amendment argument. What was the timing on that? How did that work out in real time?
Your Honor, you're correct. The original objection was burden shifting. The objection and motion for mistrial based on Fifth Amendment and burden shifting and other improper arguments was made, I believe, the first time the jury wasn't present. After the closing arguments, the jury immediately read the jury instructions, then they left the room, and then the motion for mistrial was made on that basis.
And do you think that's a timely objection?
I think the objection was timely, and originally in burden shifting, I think the context makes it clear what the basis for the objection was, and I think the motion for mistrial was made contemporaneously enough the first time the jury wasn't present to preserve the issue for appeal. But I would note that on appeal, we're arguing both burden shifting and a Fifth Amendment violation. So I think that it's preserved and argued on both bases, and that the court should address the merits of it.
But one of the concepts of an objection is to give the trial court an opportunity to correct any error. And what opportunity by the time the jury is, closing arguments are done and the instructions are read and the jury goes back to deliberate, what opportunity does the trial court have to correct that error?
Well, you're certainly correct about the reason for the rule. I think the judge gave a curative instruction when the objection was made and certainly placed a burden of proof on the state. So, and then the judge was...
That's different than the Fifth Amendment argument.
I think the burden shifting is broader than the Fifth Amendment, so I think it's fair to say it encompasses both.
How does it encompass both? I mean, if you make an objection that they're shifting the burden of proof, that's an entirely different concept than commenting upon a defendant's right to remain silent.
Well, I think when you comment on the right to remain silent, you're suggesting that the defendant should have testified and has some burden to prove his innocence. So I think they're related.
The converse isn't necessarily true, though. But when you talk about burden shifting, you're not necessarily talking about...
I agree, but I think in this case that it's true. I agree the converse wouldn't be true, but when you have the burden shifting argument and they're saying two people were in the room and only one testified, it's suggesting to the jury that he has a duty to testify and prove his innocence, and that's not the law and not the case. So...
Talking about preservation of that error.
I understand. I think the context makes it clear that the judge knew what the reason for the objection was, and that it was raised later as a motion for mistrial. So the judge had the ability to correct it by granting the mistrial.
All right, you got a little bit over a minute to save for rebuttal time if you need it, sir.
Thank you. I'll reserve the rest for my rebuttal.
May it please the court, my name is Chris Davenport and I represent the state of Florida. I would like to start with the custody issue. The trial court did mention the Johnson case, which was good law at the time. Wheeler came out while this case was still in the trial court. Nobody ever moved for rehearing or asked him to revisit that issue. Probably part of the reason why is the confession didn't come in. So that's certainly not a basis for a new trial here. They had some problems with translating it, and there was some debate about that.
When we grant a new trial, aren't we going to have to address that?
I think if this court were to grant a new trial, it should recommend revisiting that issue under the proper
You think that we're going to grant a new trial?
I don't think you should.
Okay.
That's a different question than what he asked you.
He asked if I think you will. Well, it's always hard to read, and I'm certainly not giving up yet.
Tell me it's not hard to read me.
Well, I'm going to go with the hard to read here, and let me address the jury instruction issue. The jury instruction issue, let me reiterate, we're talking about fundamental error here. He didn't object below when this could have easily been fixed.
Error, though, right? You concede that, right?
It is not a correct instruction.
Well, I mean, it's an erroneous instruction. It leaves out the most critical element of the crime.
I don't believe it leaves it out entirely, though.
Well, because it has the definition, you mean?
It has the definition, and when you look at the definition, it says, this is the intent required of the person who's doing the act. And they describe what the act is under the elements.
The element of the offense did not include lewd and lascivious.
They did not say intent was an element of the offense, but they called the crime lewd or lascivious.
It's unfathomable to me that an experienced prosecutor, I presume that we have an experienced prosecutor and an experienced judge give this instruction. I just don't see how that could possibly happen.
Well, clearly they should have paid closer attention, but...
You do acknowledge that whether the touching was done in a lewd act or was incidental to playing and to tickling, that was absolutely an issue in this case.
I do not acknowledge that, Your Honor, especially...
I know you don't, and I'm surprised by that, quite frankly.
Well, here's why not. When the victim described this touching, and that's what we're going by, is the testimony of the victim. Here's what's at issue. He hugged me, he would work his way down to my butt, and then he would work his way up to my breasts. This is a 14-year-old girl. Over the clothes and under the clothes.
Was there an issue made, both on cross-examination and on argument, that the touching in this case was not lewd and lascivious, but was incidental?
Not incidental, but tickling or affectionate.
Was that
and they talked about that.
Was it discussed on cross-examination, and was it argued?
In the context of touching her butt, which is count 3. Never once in this trial did anybody say he accidentally brushed her breasts and that's what she was talking about. Or I was tickling her and sometimes it would go, onto her breasts accidentally. There was never anything like that. It was, in Korea we pat children on the butt and it's very normal. So at the most, now, clearly the defense in this case was she made this whole thing up. They mention in passing that, you pat children on the butt and that's normal, that's not lewd. They mention that in passing. I would submit, when you evaluate these things, you have to look at the context of the case that was actually tried. And as lawyers, we sit here and say, well, they didn't define lewd or lascivious as an element. I would submit a lay jury doesn't know the difference between an element and another part of the instruction. The crime is called lewd or lascivious molestation. And they instructed the jury...
That juries actually pay attention to the instructions that judges give?
We have to operate under that assumption, of course. And they do, and I'm not saying they blow off the instruction. I'm saying when you look at this instruction, is it fundamentally erroneous when it defines what lewd or lascivious is, the crime is called that, there was never any argument, this touching is per se criminal, so we don't have to prove any intent. There's never any argument like that, so that it's not a situation where the state is trying to take advantage of an instruction. It's defined in there, it's defined as an intent, and it's defined as an intent by the person who did the act, and the element is you have to show you did the act. I would submit a common sense understanding of that, not a bunch of lawyers.
Davenport. In other words, you have a erroneous instruction that was given, that wasn't objected to, and now the state's claim is that the defendant conceded that issue, or do you have to establish that they conceded the issue, or what do you have to establish?
We have to establish that it wasn't disputed. It wasn't a disputed element.
It was not a disputed issue.
Right, and
Okay.
a disputed element.
Right.
And
Well, did they concede the issue? Did they concede that element?
They didn't concede anything. I mean, they never really went through it in that sense.
Well, I mean, absent a concession about that, like the example that counsel gave with the age, where he would agree that he's over 18. Absent a concession, doesn't the defendant always have the privilege to argue to the jury that, that element hadn't been proven? Doesn't the state always have the burden to prove all the elements?
Yes. But we're talking about whether or not the jury instruction, which included what lewd or lascivious is fundamentally erroneous in this context. And, even if the buttocks won.
That instructions say that the intent is an element. It says at the bottom, it defines lewd and lascivious to mean the same thing, but the elements are 1, 2, and 3.
Well, it doesn't say that it's an element, which is what's missing, is it doesn't list it as an element. But it says, the words...
So you agree that the essential part that you claim is in the definition is not listed as an element in that instruction?
It's not listed as an element. I would submit that...
It goes through this and it says these are the elements that you're supposed to, the state's supposed to prove beyond a reasonable doubt, 1, 2, 3, and that's not an element. What's the jury supposed to think?
I think attorneys would say, gee, that's not an element, there must be something different here. I think a lay jury would say, it's lewd or lascivious molestation. There's no argument that just brushing buttocks is lewd or lascivious.
Yes, the jury would be smart enough to pick up on the definition and include that as an element, although the instruction doesn't say it's an element.
No, I think you need to look at the context of the instruction in the context of the case, where the case was tried.
Do you have any idea as to why they just didn't give the standard instruction?
I have no idea. But I would say again, it's defense counsel's obligation to look at these instructions and object if he has a problem with them. And I know everybody says, well, the prosecutor didn't, and the...
It's going to prepare them. Wouldn't you think they'd have an obligation to all get it right?
Yes, but the state has an obligation to get everything right. That doesn't take away the defense attorney's obligation to object when there's a problem. And the whole point of this is objecting, put the trial court on notice.
The whole point of fundamental error is that it's error even though he doesn't object.
Right.
And leave an essential element out of the jury instruction and then put it in a definition, and then we're supposed to speculate, well, maybe the jury could have been smart enough to pick up on that and include it as an element. I think it's...
Well, I would submit that it's speculation to say that they just ignored this definition and convicted somebody of lewd or lascivious molestation without finding something was lewd.
We're saying that they followed the definition.
I think that the logical thing for us to do is to say the jury followed the instructions and said these are the elements, 1, 2, 3. and that's what they looked at.
I think that requires a consideration that they just ignored the definition of ludo lascivious. Why, I mean, I think a layperson would look at that and say...
Under
Pardon?
this instruction, they had no reason to even look at the definition.
Well, but it's in
Because it
there.
doesn't tie to anything in the instruction.
Well, but it's tied to the act, and it says, this is the intent on the part of the person doing the act, and the act is what the state had to prove. I think a common sense reading of that, not an attorney reading, but a common sense lay reading is, this is ludo lascivious, but especially as to the breasts and the genitals, even if count 3 about the touching her butt, because that's what was even remotely disputed. The defense here was, she made this whole thing up. They mentioned it a few times, and you pat a kid on the butt in Korea, it's much more normal there. They never said, and yet touch a 14-year-old's
He never
breasts or
acknowledged
genitalia.
He never acknowledged that occurred, period.
Right, he never acknowledged that occurred, period. It was not a disputed element, it was, did it even happen?
Got the burden of proof in this case?
The state does. But they had to prove that it happened, and the defense was, it didn't happen, not, it was accidental, it was incidental, it was tickling. That wasn't the defense. The defense was, certainly as of the breasts and genitalia, it didn't happen, and that makes that not a disputed element. I think you have to read this in the context of how the case was tried, and I would submit at least as to counts 4 and 5, this isn't fundamentally erroneous.
About the fifth, the comment on the defendant's right to remain silent.
Okay?
Do you think that was not preserved?
That was not preserved because the grounds he raised at the time were a shifting of the burden of proof, and the court gave a curative instruction about
Do
that.
you think that the later motion wasn't sufficient to preserve that?
I think it was untimely. So I think you have to look at it, whether it was fundamentally erroneous. Because, after the jury was left, again, the court gave a curative.
You don't even concede in your brief that it was a comment on the right to remain silent.
Well, I think it was inartfully phrased. I certainly don't think it was, counsel said it as, 2 people were there, you only heard from one of them. That's not how, she was talking about all the evidence in the case and said, yeah, nobody else saw that, the victim was the only one there, and you heard from her. And I think in that context, it's slightly different. It was certainly inartfully done. Had they raised an objection, I think the court would have given a curative. He gave a curative on the ground that they raised. So again, we're looking at it as, was this fundamentally erroneous? And let me reiterate, this wasn't a jury who just blindly followed what the prosecutor said or what the detective thought was credible. This jury acquitted him of the more detailed charges, the ones that weren't mentioned in that phone call. So this wasn't a jury that was overly swayed and couldn't consider the evidence.
Full comment on the defendant's right to remain silent. What do you think about the bolstering of the credibility?
With the detective?
Was that inartful as well?
I think that was not preserved as well, because when...
Inartful?
I would not have gone there. We made the argument that the door was open to that. I mean, I think it's closer.
It is improper to ask a detective.
To ask if
do
they
that, right?
believe the victim, yeah. But let me reiterate, harmless error here, because the story...
He made the right objection, and he was overruled, right?
He made the right objection, but he made it too early, because that question didn't go to this victim's credibility.
He really had a pretty good way of predicting what was going to happen.
Well, and he should have objected when...
That's exactly what the guy said after he made the objection.
He did, and, maybe that planted the idea, who knows? He should have objected when the guy actually went there, not when they were asked just general questions, do you always believe these guys? But let me reiterate, the story she told to the detective was a story about the sexual batteries, and the jury acquitted the defendant of those charges. So again, even if that testimony should not have come in, or was it wasn't, it was harmless error, because it related to charges that he was acquitted of. This isn't a fantastic trial. You're not entitled to a perfect trial. You're entitled to a fair trial, and the state would submit that this was fair.
The combination of all the errors in total,
That's my response to that. If this was a jury that had blindly followed everything the victim said or everything that was vouched for the prosecutor, I think that would be a harder argument to make. But again, it's not a perfect trial. We certainly agree with that. The question is, was it, can you trust these verdicts? Was it fundamentally fair? And we submit that it was. Especially, again, I wrote counts 4 and 5. I would ask the council where in the record they ever said touching a breast is normal in Korea and it wasn't done with lewd intent. This is a 14-year-old girl. You don't touch breasts. You don't touch genitalia. It's obviously lewd. It's not a dispute. The dispute was whether or not that actually happened. So we would ask the court to
All right,
affirm.
thank you. That was one of your longest arguments before this court, Ms.
She had a lot of work to do.
Why don't you confine your rebuttal to the confession issue? All right? You got a minute left.
Sure. Your Honor, I think the state argues that the confession didn't come in, and the actual words of the confession didn't come in. But during this interrogation without Miranda, there was questions asked, and he was asked to make a drawing, and that information came in through the testimony of one of the detectives and through her pictures. So it's our contention that the questioning would have ended, and had he been provided Miranda warnings, as he was entitled to because he was in custody, and that there was prejudice here, even though the actual words of the confession were not admitted at trial. So for that reason, we think we're entitled to, Mr. Yee is entitled to relief on that issue as well. And it is an issue of law, so I think the court could address it and say that he was in custody and he was entitled to Miranda warnings and none of that could come in, and I'd ask the court to make that finding at this level.
All right, sir.
So for that reason, and all the reasons previously stated, I'd ask for a new trial and a finding that he was in custody and entitled to Miranda
Do
warnings.
you think that there was a dispute as to the touching of the genitalia and of the breasts?
Your Honor, as it's addressed in the testimony and the closing argument, I think all 3 counts were disputed as to whether the touching was incidental, joking. The state stood up and said today, just now, that there was testimony about hugging. And certainly when you hug someone, you could rub against the clothing covering the breasts. And that was addressed in closing and in the testimony. Certainly if you tickled someone, you could rub against the clothing covering the genitalia. There's testimony about tickling, there's argument about tickling, there's testimony about hugging, there's argument about hugging. All of them are in dispute. And most importantly, they were addressed by both parties in closing, and in closing on page 406, addressing element 2 of the breast count, the state restated the elements of the instruction, leaving out the lewd intent. So even in their recitation of the instruction on count 4, which addressed the touching of the breast or the clothing covering the breast, they left out the lewd and lascivious intent. It's clear all 3 counts were disputed.
Answered the question. Thank you. You're out of time. All right.
Thank you, Your Honor.